the Constitution. You just hold that up and it stops bullets and fire and terrorists and everything.
Pure fucking nonsense.
So there's 3 buckets that something can fall into. Something can either be manifestly real, reality bucket, a cue ball is round, reality bucket thing, right? Billiard balls are round is a reality bucket certainly thing. Then there is legal things, which is you were driving. That's a legal bucket, right? It has something to do with reality in some sense, but it is a legal bucket thing because it's not merely describing a real actual event. It's adding a bunch of mumbo jumbo to it. And then there's a third bucket, which is ethics, right and wrong, should. Anytime you use the word should, anytime you use the word shouldn't, anytime you use the word right or rights, anytime you use the word wrongdoing or wrong, that is an ethical bucket thing. Because it's not describing reality. It might describe what ought to happen, what should happen, in the future reality. But it's an ethical bucket. And lawyers are constantly trying to take that legal bucket and shove it in the place of the other 2. Whenever you ask about reality and whenever you ask about ethics, right and wrong, should and shouldn't, rights that you have, they very much want to knock that bucket aside because they certainly don't want to talk about reality and they certainly don't want to talk about ethics. They want to talk about their opinion. And so drawing that distinction between, I'm sorry, I understand that you have something in your legal bucket that addresses this issue, but I am talking about reality and I am talking about ethics. And we can, after these 2 things have been addressed, address your bucket of legality. And you do see, I mean, is it clear that they're trying to shove this legal opinion in place of evidence and right and wrong?
And that's what I'm needing help with. Like Mark says, breaking through those legal fallacies, those philosophical arguments.
So how do we combat that?
And that's what I'm asking you.
Okay. So that is okay, great. Well, I'm just making sure we have the right question on the table.
Yeah, so, I know. I'm not trying to pretend like I'm in court, but I'm just saying, that's what I'm asking you. If you were in my situation and you had the trial coming up, say next week, and
I would get the confession.
Huh? I
would get that confession, and I wouldn't ever think that I have a trial coming up next week. By the way, unless someone put a gun to my head, there is no way in which to end up in trial.
Well, they're forcing me. Well, like you said, it's 2 different forces. But they have morally decided on their end without my consent or anything, or even answering my motion, as you can tell, that it's best for them to move me forward. So they're going to proceed with the trial, and she's made it clear to me that if I don't show up, that I'm going to be arrested.
You're kind of ignoring my point. They're morally persuading you to move on by ignoring the points that you're raising. And by ignoring the points that you're raising, get you to ignore the points that you yourself are raising as well. Because all it takes is for any point along the line, if you start ignoring it with them, then retroactively everything they've done is fine. All it takes is for you to ignore it and cooperate with them for one step of the process, the proceedings, and everything is made good that they've done. Every shove that they've shoved you through that door is fine as long as you at some point are persuaded to cooperate. How do you leverage the idea that you are uninformed and that you wish to be informed and that you do wish to plead guilty at every step? Your wish is to plead guilty there at that step, and you have a question about the cause and nature of the proceedings.
So how do I use that as my leverage? Like, I understand what you're saying, but how do I use that as my leverage that now that we have the problem where they've completely denied it, and I've already continued to challenge, because it's not been one time that I haven't continued to challenge jurisdiction.
How about this hypothetical? Okay, what do you believe would happen if you walked in to the next whatever and said, do I have the right to plead guilty here today? What do you think they would answer?
They would be ecstatic. Yes, you do.
Thank you very much. Do I have the right to make an informed and knowing plea of guilty here today? I'm sorry, an informed and voluntary plea of guilty here today. My bad.
So taking Mark's way of going
No. What do you think? What do you think they'll answer? No. Don't break character yet. What do you think they'll answer?
They would answer. I think that's where I would get resistance, because then they would say, well, see, they would ask me for clarification.
Okay. So how do you think they'd do that?
The judge would be like, based on what I've experienced with her, she would rub her head and say that she doesn't understand it. And Ms. Wilson, can you please clarify, since you have stated on the record?
Yes, thank you. I'd love to clarify that question. Which word is giving you trouble?
So I'm baiting in theory.
A bit. I mean, you're saying, hey, this judge just confessed to being an idiot about a simple English sentence that should be known to any first-year law student, certainly, and probably any damn high school senior, right?
Right.
And she confessed that she was confused about the sentence. Okay, let's deal with that. Which word is giving you trouble? Is it the informed? You don't know what informed means? Then we certainly have a big problem if you don't know what it means to be informed. And that would certainly explain a lot of these events and a lot of the proceedings so far. So
just to make sure, I understand it, and this is not a question, it's a restatement of what you stated.
Okay.
You will walk into court as it's, of course they haven't picked the trial, so it's the beginning of trial.
Nope, it's not. No, it's not.
Right. You're correct. It's not the beginning of trial. You're correct, because there has to be. You finished. You explained how.
It's the minute before. It's the minute before the beginning of trial is fine, but it's not the beginning of trial, because if you pled guilty, there would be no trial. Trial would not have begun. And you bet your ass if you had a double jeopardy issue, suddenly they'd be on the argument that, the trial had not yet begun, so it's not double jeopardy yet. I mean, they constantly argue that trial doesn't begin until the jury's seated. So it's not the beginning of trial, no matter how you cut.
You were saying earlier, I would expect to go to trial because there hasn't, even though they're making it seem. So I get what you're saying. You're saying they're making it as an illusion.
How can you go to trial? How can you go to trial if you're not informed? If you have a relevant and unanswered question about the cause and nature of the proceedings on the table, it is clear that you've not been informed. The mere fact that you have a question that is relevant and that is unanswered and that is about the cause or nature of the proceedings means that you're not informed and you're not ready to begin trial, because it's called stating a case. When he informs you of the cause and nature of the proceedings, that's what's called stating a case. And you're showing that the prosecutor has not yet stated his case by having a question on the table that's not yet answered. And they're trying to make that question go away. They want to make you abandon all the embarrassing questions. And your job, so to speak, is to keep them on the table. Because as soon as there's not a question on the table, you're ready for trial. And as you have a question that is unanswered and relevant on the table that they have not managed yet to get abandoned by whatever means that you're not in trial. You're not ready for trial.
So just to stop you there, to clarify, when you say, as long as you don't give up and you haven't left that off the table, how do you not leave it off the table? Because I filed the motion quite a few times.
I get that.
Okay.
When they deny the motion, they expect that question to be gone. That's the point for them to deny the motion. And you're trying that mechanism of communication over and over and over again, and they have a standard response to that, which is denial of the motion. So the question to me, which I've said here a couple times now, is, okay, you've denied the motion, the means that I used to communicate this point. Now I'm asking you, Judge, what mechanism do you have to address the point that I made that still remains, even though you've denied the motion? You've denied the way I've communicated it. Fine. I don't care. It's been communicated. I don't care about having communicated. I care about addressing the point, which is, I'm still trying to figure out what facts cause you to know that you have jurisdiction, because they're being kept secret from me. And I need to know them in order to prepare my defense. And in fact, I need to know them. And once I know them, I probably won't even prepare a defense. I'll just plead guilty. If I discover that you have facts that have been fabricated that let you know it's true falsely, then I will prepare my defense to show those facts to be false. That's what it means to defend yourself in a trial.
Okay, I get what you're saying. So pretty much, I get what you're saying. Okay, so I'm throwing it back on the court, or as well as the prosecutor, with the burden of proof, which they haven't provided the evidence that the jurisdiction applied to me. So
they're convinced that they have.
So even though they deny my motion in that, I'm not properly prepared to go to trial, since you stated that my motion is denied, but you haven't provided the evidence in order for me to prepare myself for trial.
Right. If you went into court and you weren't wearing a hat, and the judge said, I order you to take off your hat, and you said, I'm not wearing a hat. Nonsense. I hereby officially decree that you're wearing a hat and you need to take it off, or you're going to be held in contempt. See, the judge's decree does not change reality is the problem. And so if you're saying, I have a piece of information that I need, and the judge here says, I hereby officially decree that you no longer need that information. It's like, wait, no, that didn't change reality. I still need the information. I hereby decree that you've been given the information. Well, Judge, that's interesting, because here I still don't know the information. The fact that you decreed that I know it doesn't change the fact that I don't know it. Do I have the right to be informed of the cause and nature of these proceedings? Or do I merely have the right to have you declare that I have been informed of the cause and nature of these proceedings? They're very different things, right? It's an attitude difference. A very, very nuanced attitude difference. I get that it's very difficult to kind of get yourself into that gear, in that it's like, wow, when the judge says, I hereby denounce your question, it doesn't make the question answered. Do I have the right to the answer? Yes. Okay, here's the question. I hereby declare that that question's gone. Do I still have the right to that information? Yes. Well, then I still need the information. Well, I hereby declare that question's been answered. That's kind of how the rut that you've been in, right?
Right, and that's pretty much where it is. And the thing is, like, the judge is doing all the talking. The prosecutor won't say a damn thing.
That's quite normal.
Like he has shit in his face. He doesn't say anything.
That's quite normal. That's very normal. Because there's a problem. If the prosecutor adds information, he has a separate problem to deal with, in that he's changing his pleading. It's like, okay, so thank you very much for that piece of information, Mr. Prosecutor. Why didn't you include it in your original pleading?
So what should I say when they say, because my lawyer thought it was a great idea to have an evidentiary hearing, which of course that's a joke.
Right.
And
it could be a good thing, but that lawyer doing it probably wasn't. Yeah.
Right. So the prosecutor feels as though that the only time when he stands up and says anything, well, we have an evidentiary hearing where the cop says you were in Chandler, and you said you were in Chandler, and you were driving the vehicle. So
you made all these confessions in this evidentiary hearing, sadly, because that asshole defense prosecutor's assistant called the defense got you to confess a bunch of crap, right?
Well, that was in the police report. I didn't confess anything. That was in the police report, and that's what he's saying.
Oh, I'm sorry. I thought you just said that you said that you were in whatever. Okay, I'm sorry.
No, he's stating that that's what the officers are saying, and that because I had the evidentiary hearing, that's validating what the officer said, proving that I was in the car and that this and that. That's pretty much what he's saying. Like, oh, you had an evidentiary hearing with the officer, and in this evidentiary hearing, which was the purpose was to debate that you did make a correct turn.
Wait. Again, you're into the okay. Avoiding all the issues of merit. Okay. The only one I'm concerned with is the evidence of jurisdiction, because the evidence, if the codes apply to you, you should plead guilty, right? Because if the codes apply to you and that court is the one to decide it, you're screwed. There's no winning in that situation. The question always is still hinging around, does that code apply to you or not? Right? Because if that's already been decided, you're toast. That's the main crux issue here, is whether or not the codes apply.
That's something that the court can decide. Like, how would the court decide that?
No, I'm sorry. Let me. Facts are not decided. Okay, so reality isn't changed based upon a judge's opinion. If a judge said that pi is 3, pi isn't changed by that. Facts are discovered or falsely discovered. They aren't changed by an opinion. So you're either, if a judge said you're 7 foot tall, presuming you're not, then he doesn't find that you're 7 foot tall. I'm sorry, that's been decided. You're 7 foot tall. The problem isn't changed. Either that court has jurisdiction in reality, or it does not. Is that making sense?
Yes. So how was the evidence? So just so I can understand, by the prosecutor referring back to the evidentiary hearing, what does that have to do? That's pretty much like you're saying that's not fact of jurisdiction.
Well, apparently jurisdiction wasn't part of that evidentiary hearing. How do you know it's true that this court has jurisdiction? How does the prosecutor know that it is true when he says this court has jurisdiction? What led him to know that to be true?
I get what you're saying. So my response would be, I object. The evidentiary hearing did not mention or discuss jurisdiction, so that doesn't serve as evidence of jurisdiction.
Correct.
I get it. Okay. It takes a little bit to get through, but I get what you're saying. You're adding 1 + 1 + 1, this equals this. So I get what you're doing.
Right. They keep changing the question. Because in their mind, jurisdiction is a given. And the idea that jurisdiction could be questioned is just beyond them.